when they would argue, did you
Welcome back to Law News Network, everyone. I'm Heather Hansen, and I am so excited about this special segment that we have going on for you. We're going to be talking about defamation. We're going to talk about it globally with a well-known Philadelphia defamation attorney, but also a general attorney for plaintiffs, Jim Beasley Jr. Jim, welcome. Happy to have you here with me this morning.
Happy to be here. Good afternoon.
We also have here in studio Eriq Gardner. Eriq is a senior editor for The Hollywood Reporter and able to talk to us a lot about this Bill O'Reilly issue that came up last week and the specifics of that. So welcome, Eriq.
Thanks for having me.
It's great to have you both here. I want to start, Jim, because we already have a question from one of the members of our chat room that's a basic legal question here. What has to be shown or proven in a defamation case? And I know this is your area, so why don't you let them know the answer?
Well, there's a couple different things. It depends on who the people are and what the issue is. In a regular defamation case that doesn't deal with public figures or public officials or issues of public concern, it's relatively basic. One makes a private person makes a complaint about a private event to another private person, and kind of the older rules apply, where it's almost like the person who's accused of the defamation has to prove the truth. When you shift into public figures or matters of public concern, things like that, then the burden shifts, and that's from that New York Times versus Sullivan case from '64 and then forward, where the person making the accusation has a much higher burden of proof. They have to prove either actual malice or reckless disregard for the truth from the person who made the publication, but then they have to prove falsity. So depending on what the issue is, like you're talking about this Bill O'Reilly thing, that's what they're confronted with, with the latter, where you've got a much higher burden and you've got to prove falsity.
So in this situation, Bill O'Reilly will have to prove, if he pursues this case, he's going to have to prove actual malice on the part of Michael Panter, who posted that thing on Facebook, and he would have to prove that what Michael Panter posted was false. So I want to bring in Eriq to this conversation a little bit. Eriq, tell us, for those of the ladies and gentlemen who are watching that don't know about it, tell us a little bit about what happened last week that led to this, and then about what O'Reilly filed.
Sure. Well, the background is that Bill O'Reilly had just been revealed to have paid $32 million to settle a sexual harassment claim, and that's a huge figure. So, Bill O'Reilly was on the defensive, scrambling. There was lots of talk about how this would affect Bill O'Reilly's future. And here, Michael Panter, who apparently is a former lawmaker in New Jersey, posted on Facebook some more information. Look at how far Bill O'Reilly would go to really go against his accusers. In his post, he said that he had once been dating this woman who had settled with O'Reilly, and that he was with the woman in a car and overheard a conversation where O'Reilly had called him up and said, this other woman has a claim against me. She lives in your building. Tell me more about her. Give me the dirt. What's her sexual history, and so forth. So evidently the conversation didn't go places, but Mr. Panter had just brought it up as an example of his his cross with O'Reilly.
Right, and guys, do we have that post? I think that we may have that Facebook post in our assets. If we do, I'd like to put it up on the screen. But the thing that's interesting about it is the reason Panter says he put it up was because O'Reilly has made the claim that no one ever complained about me. And so Panter's point was, listen, if people complain about you, this is what they get. They get him trying to get into their information. And so therefore he posted this little blurb about O'Reilly. That blurb then, Jim, was picked up more nationally by Gabe Sherman, I think, who is one who has written quite extensively about Fox. Given that Panter didn't put it in any sort of a public place except for Facebook, is that enough of a publication to meet the standards that are necessary in defamation?
Sure.
Yeah. So
I mean, if you post something on Facebook, it's it's a publication. I mean, you can't have a publication just between like you and me. Like, I can't say something about you and then you bring a claim. But if third parties get involved, then that at least triggers a potential for a claim.
Yeah, so that's important for our audience at home to know and understand, that sometimes I think that people think that things they put on Facebook or Twitter or our chat rooms are free and clear, but you are certainly publishing things when you're putting it out there for more than just two people to look at, and therefore you're starting yourself on the road to a defamation claim if you're making claims that fall within the definition of defamation, right?
Well, I mean, let's be clear. Based upon everything I saw, it doesn't sound like Panter did anything that was defamatory. But to the question of, was there something that he posted out there that at least meets one of the first criteria of, hey, is it at least communicating to third parties? The answer is yes.
Right. Now let's talk a little bit, and Jim, I want to come back to this issue with you because I think it's important to get to how much Bill O'Reilly's reputation was harmed. But Eriq, you mentioned the $32 million settlement with Lease Wheel, and Sky, one of our viewers, just asked the question. She wants to know a little bit more about that $32 million. I don't think we know all that much. Tell us what we do know about that settlement, and then I want to talk to Jim about how that impacts this current defamation case.
Sure. The $32 million was with a woman named Liz Weil. She was a legal analyst at Fox News for many years, and apparently she had come forward to accuse O'Reilly of sending lewd messages to her, of developing a relationship that might not entirely have been consensual, and so forth. This was never filed in court. Mm-hmm. It was not even arbitrated, but a draft complaint was sent to O'Reilly's attorney. It was also sent to 21st Century Fox, and in the midst of that, that's when O'Reilly decided to settle it. He says he settled it to spare his children, grief from the ordeal of waging a public litigation, but nevertheless it was kept quiet until many months later when the New York Times reported on it, when federal investigators were actually looking into how Fox has kept these settlements quiet. It made lots of splashes. Nobody knew about it, and here it is.
I mean, the $32 million, Jim, I mean, that is not, that's a large settlement by anyone's estimation, I would say. What does that tell you about her claims and the veracity of her claims and the strength of her claims?
I mean, one can certainly make an inference as to the strength of the claims and whatever messages or who knows what she had. Obviously, that's a large number. I mean, Megyn Kelly made a point the other day that the O.J. Simpson civil case was right in that range, and that was for, the amount the jury found in the civil case for, right, for the murder. So obviously, it's a big number. It's not a number that you see thrown out every day for cases, but the particulars, I mean, no one's going to know.
Now, given the fact that he has settled a sexual harassment case for $32 million, does that make it harder for him to prove a defamation case against this Michael Panter?
Well, if you're talking about proving a case, the facts will kind of run on their own. I mean, if you're going to get a judge to permit a case to go to a jury, for example, no, I don't think anybody's going to say that he's libel-proof. I mean, that's not where I think it is. I mean, that's one of an argument that the defendants would make when they're trying the case. But as a matter of law, I don't think a judge is going to find that he's libel-proof.
Well, let's back up a little bit and tell us what that means, libel-proof. Go ahead.
So, the old law school expression is, who's the can't remember the guy's name, and I'm going to say he's libel-proof. But take like Al Capone or something like that. If somebody, and he's been in jail, and he's, and I'm not saying this is an analogy to Bill O'Reilly, but just back to the law school definition of what libel-proof means. Mm-hmm. If somebody wrote an article and said, I believe, put aside the opinion for a minute, that Al Capone is a criminal. All right, well, the guy's already been in jail a ton of times, and I mean, how is that really going to harm him? And I think the court at that point would say, all right, look, I'm just going to take judicial notice, meaning that I'm going to just become aware for my decision making of the fact that this guy's done all this other stuff, and you're accusing him of what 5 or 6 other jurors have already found. I mean, so that's the context, in that setting, and I don't think you get anywhere near that with this.
Right. So in your opinion, Bill O'Reilly is not libel-proof, and therefore, at least as far as that goes, he can pursue this type of a defamation case against Panther.
Yeah, I mean, the main thing would be just to have careful jury selection, and you would get folks that, that weren't either swayed by it, or you would do your best if you're prosecuting the claim on Mr. O'Reilly's behalf. You do the best you can to get rid of those jurors, and the defense will do their best to get those folks on a jury.
What do you think, well, before we get to the chances of O'Reilly's case being successful, given what little bit we know, I want to talk a little bit about the way that it's been filed, because there's no complaint, and yet it's a writ. So I'm going to start with Eriq. You had talked about this in a tweet that actually is what piqued my interest in this whole story, because there's been some confusion about whether or not a case has actually been filed. Tell us about what it is that has been filed here.
Well, there are two ways in New York that you can actually file a case. One is you serve what's known as a summons and a complaint, and the complaint is something that goes into what you alleged, how do you think it violates the law, and it includes a lot of the factual details included in the case. The other way is called a summons with notice without a complaint, and what a summons with notice does is that it just puts the defendant on notice that a case has been filed. It very briefly, talks about what the claim is, but it doesn't really go into details. Here, we don't know exactly, what O'Reilly is claiming is defamatory. That would come later. A defendant, after getting notice of this, can demand a full complaint, and O'Reilly would have 20 days to file it. But I did see a lot of reporters say, well, maybe this isn't actually a lawsuit, because what we only have here is a summons. No, it actually is a lawsuit. This is something that New York says itself, that it's a lawsuit. That doesn't mean that it's actually going anywhere. Time will tell to see whether O'Reilly follows up with the complaint and follows up with pursuing this litigation. But yes, a lawsuit has been filed. I think some reporters want to try to appear smart on it, where they say, well, there's no lawsuit that's been filed. Others might are trying to be a little bit careful here, right, for unknown reasons. But I think that lots of lawsuits get filed these days, and a lot of reporters treat them as some sort of huge public statement. So there's a lot of ceremony around when a lawsuit gets filed. And in this instance, some reporters didn't want to, give O'Reilly that extra credit of actually filing a lawsuit when he actually did. Yeah,
I mean, Jim, we see summons filed all the time, and that is the beginning of a lawsuit. What's a little bit different here is that there's actually a little bit of a statement of fact. What do you think about this position that perhaps this is only shots being fired and not a real lawsuit?
Time will tell. I mean, I would think that given everything that he's said so far, and he keeps saying more information's coming out, I think that now that he's kind of started, he's got to file a complaint. He's got to move forward.
Well, and I'd like, guys, are we able to put up the summons and the language in the summons? Because if we are, I'd like to be able to show that to the audience and talk about it a little bit. While they look for that, Jim, I think I'll just read it to you in case we're not able to get it. He says, this action seeks redress. No, that's not it. This action seeks redress for defendant Panther's intentional. That's not it, guys. So there we go. This action seeks redress for defendant Panther's intentional, malicious, and bad faith actions in making defamatory and false statements in a publicly available social media post. And then he says he wants damages for the public hatred, ridicule, disgrace, and permanent harm to his professional and personal reputations. Let me ask you, Jim, how does one parse out the harm? I mean, if this $32 million settlement hasn't done harm to his reputation, but yet this Facebook post about a telephone call to an assistant did, how do you, on either side of these types of cases, how do you see that played out?
Well, I mean, obviously there's going to be, assuming that the judge permits the matter to proceed, and that goes back to the other things we spoke of earlier. There's going to be aggressive discovery. There's going to be, hopefully, the plaintiff's side will be able to get admissions and statements that will be useful for them. And obviously the defense is going to try to say, hey, look, what more do you need? How is this compared to the other stuff? But then it's just a question of, when you're trying the case, how you're presenting it and how you can be persuasive to minimize that 32 million or whatever else is out there, if there is anything else.
Right.
And explain why, and have, Bill O'Reilly talk about why this one was particularly troubling for him. Because remember, it's not just, you can have, and we've had plenty of cases where there's no one that comes forward and says, well, I think less of this person. You don't know who's not calling you and calling someone else instead. So you have as much of an emotional issue and damages for the plaintiff as you do for, some third party thinks less of it. You have to have some of that, but it's not only the only damages. He's got other avenues to seek redress.
Jim, I want to ask you, is O'Reilly running the risk of opening up a Pandora's box here? Because with discovery, and if truth is obvious, well, talk about truth being a defense and how that will play into the discovery here. Well,
yeah, if what somebody who's accused of defamation says it's not true, or it is true rather, forgive me, then there are some types of things where there can be out of context comments and matters that could be what's like an invasion of privacy type tort. But for just a defamation claim, which is what we're talking about, if there is nothing false about it, and remember, a public figure in this situation has to prove falsity. Mm-hmm. If they can't prove there's anything false, then they're not getting to the jury.
Yeah, it's going to be really interesting to see how this plays out. Jim, I wanted to thank you so much for being here with me today and being with Eriq and I and describing the law to everyone, because I know this gets confusing, and we'll continue to call on you as this issue continues to evolve.
Okay.
Thanks, Jim.
Have a good one.
You too.
See ya.
Eriq, the one thing that I wanted to follow up with there is this whole talk about whether or not this was just filed as some sort of a publicity stunt. We saw Eric Bolling filed something similar before he left Fox, where he filed a summons against a journalist who had publicized some things about him that he didn't like. Do you know what happened with that case and whether that's moved at all?
It has not. It has not moved at all since the summons was filed. There has been no demand for a full complaint. There has been no appearance in court by the journalist's lawyer. It's just sat there. Eventually, the judge might order cause on why this should be prosecuted or not. But at the moment, nothing has happened, and that sometimes does happen, and it's on the onus of journalists to actually follow up, because if someone is using the court as a glorified PR vehicle, then I think that deserves attention.
Yeah, and that is exactly what some people are saying, that by filing these writs, you don't have to actually go to the trouble of a complaint. You don't have to be specific with your allegations. You can use it to say, I have fought back, and yet nothing really happened.
Sure, although it doesn't take much to file a lawsuit, file a complaint either. Someone can file a complaint and then withdraw it a week later. Mm-hmm. The filing fee isn't so much, so I don't think anyone should overread into the filing of the lawsuit. But there are still many questions that we don't have. And number one is, what exactly is defamatory about what was written on Facebook? As far as I read it, this guy just says that Bill O'Reilly goes to the ends of the earth to defend himself. Mm-hmm. How's that defamatory? Even if he wanted to collect information on this woman, I don't see anything precisely in that that would
hurt his
reputation. Lead me to think any less of him. People have a right to defend themselves and even to collect information. So maybe he was collecting it to potentially smear a woman, and that gets into the other issue of damages, because this all happens in the context where he's been identified as someone who has serially paid out settlements to settle sexual harassment claims. And to the extent that he suffered any damage, whether it be that he's no longer on TV, he couldn't negotiate a new contract with another broadcaster, how does O'Reilly prove that this one Facebook statement matters more than the New York Times article that preceded a few days earlier?
Yeah, I think to Jim's point, he's going to have to say that somehow it affected him emotionally and caused him more pain for some reason. But I would suspect that we may not see much more from from this case, similar to the way that we didn't see much more from Eric Bolling's case. But it'll be interesting to see, and I know you'll be following it for The Hollywood Reporter, which is certainly one of the many places where I get my news and follow you closely. So I want to thank you for that, because it's always interesting the things that you find.
My pleasure.